Every day, somewhere in America, more than 300 innocent men, women, and children become victims of medical malpractice at the hands of incompetent and negligent doctors. Last year, over 98,000 victims were killed by doctors. More than 4 million victims are permanently injured each year. In this insider exclusive Justice in America Network TV special, our news team is on location in Atlanta, Georgia with Lloyd Bell of the Bell Law Firm, who represented his client Michael Barbour, who in 2011 came to the Piedmont Newnan Hospital emergency room complaining of chest pains. As a part of the stress test he was undergoing, a catheter was inserted in his left arm and he was injected with a benign radioisotope to view his heart for heart disease. During the examination, some of the solution from the IV was pumped into the soft tissue of Michael's arm, whereby he suffered nerve and tissue damage that led to the development of regional pain syndrome, which is a condition that causes chronic and intense pain. Michael and his wife subsequently filed a medical malpractice lawsuit against Piedmont Newnan Hospital and a nurse, Sherry Smith. The Barbours were awarded a $4.4 million verdict in damages by a Fulton County jury. As a result of Piedmont Hospitals and the hospital staff gross negligence, Michael has been diagnosed with CRPS, otherwise known as complex regional pain syndrome, by several doctors, including Dr. Andrew Coleman, a world-class orthopedic surgeon and expert on CRPS. Dr. Coleman stated that the infiltration of the IV materials had a mass effect, a crushing impact on a nerve in Barbour's arm, both from the infiltration itself and blood escaping from the vein. This is the Insider Exclusive, live from Atlanta, Georgia. It is my great pleasure to introduce Lloyd Bell to the show. Welcome to the show, Lloyd.
Thank you.
Tell our audience a little bit about your law firm. What do you specialize in?
Specialize in medical malpractice. I've been a medical malpractice lawyer now for over 20 years, and I've been helping people who've been victims of malpractice or family members who've lost loved ones due to malpractice for over 20 years. And
you come from a medical family. Your dad was a doctor, wasn't he?
He was. He was a surgeon, and he encouraged me to go to medical school.
And why is that?
I think he just thought that it'd be great to be a doctor, and I was on that path. And I went to college and was pre-med and realized that that was not my calling. I enjoyed the classes, but I knew that that was not the path I wanted to be on.
Tell us about your client in this case, Michael Barbour.
Yes, I represented a very nice man named Michael Barbour, originally from Philadelphia, had been a college football player. And he and his wife had settled in Georgia, two young daughters. And Michael had some chest pains, and he was concerned about. So we went to the hospital to have it investigated. And they decided to keep him overnight and to do what's called a nuclear stress test the following morning. And this is a test where they place the patient on a treadmill, they have him run on the treadmill, get his heart rate up, and then they inject a radioactive material into his vein, which will then travel to the heart. They take a picture of the heart, and they can see if there are any blockages or problems with the heart. Well, in Michael's case, they did not check before injecting the radioactive material to make sure the tube was in the vein.
How could that happen?
Was negligence. It was malpractice. Their standard of care, the nursing standard of care, required them to check by injecting a little bit of saline into the tube, and it gets carried up into the vein. It means it's in the right location. And they did not do this. Now, what we learned in the case is that the reason they didn't do it is because they were very busy that day. They only had one nuclear technologist, the person whose job it is to do that.
And this is not an MD, right?
This is not a medical
doctor. This is a medical tech.
This is a medical tech, and they had one medical tech for the entire facility, and she did not have enough resources to do it herself. So she had to pass this on to another nurse, and the nurse just forgot to check the what they call the patency, or to make sure the tube's in the right place. So the problem is when the doctor went to inject the radioactive material, instead of it going into the vein, it all went into his arm, into the soft tissues of his arm.
And he immediately felt it, didn't he?
Oh, he immediately felt it.
A lot of pain.
Immediate pain. The skin actually bubbled up. You could see where a bolus of this fluid was located. Yeah. And the problem is it set up a pain condition known as complex regional pain syndrome, which is a fate worse than death to some people because it is chronic, horrible pain.
And we're going to get to this in a minute. You eventually went to trial, correct?
We went to trial.
Okay, so the evidence is pretty clear. I mean, right then and there, they see that the tech made a mistake.
Well, that's how we saw it. The evidence was clear on that point. The defense came back with a number of defenses. They claimed that whatever problem he had now at trial was not related to the injection. They said that he did not have complex regional pain syndrome. They disputed the cause, what we call the causation. They said, okay, it may have come out, it may have bubbled, but that's not what's going on with him. So essentially they were attacking his credibility and his character.
Okay, and how did you address that?
Well, we put his credibility into issue. We demonstrated what a fine person he is, what a good husband, that all of his conduct was consistent with what he had reported. Right. And the jury had to determine his credibility, and they found that he was highly credible. One of the key points of the trial was there was a dispute over whether he really had this pain condition. Yes. And this pain condition can show itself by causing a temperature difference in one arm versus the other. And that's one of the symptoms of complex regional pain syndrome. Well, our expert in court touched Mike's hands and saw that his hands were a different temperature. We invited the defense expert to do the same, to touch my client's hands in court. And the defense expert said, well, I can't really tell a difference. They seem pretty close. So then we invited the jury.
That was your idea.
This was my idea.
And they objected.
Oh, boy, did they. Boy, did they.
What did they say? What was their objection?
Well, they came fast and furious. The big objection was just objection. Objection. And they said it's just irrelevant.
Well, there's no better judge of what's going on than the people who are going to determine his fate.
Of course. And the jury had to decide this issue, whether he really had this disease. Yeah. And so we fought the fight. The judge said the jury could do it. And then I turned to the jury, and the jury didn't ask to do it, which was kind of awkward for a moment. But finally, one of the jurors said he'd like to do it, and then another juror and another, and pretty much the entire jury.
Did they say anything while they were touching his arm?
No, but you could tell from the gentle way they touched him.
Did the judge say, you can't say anything, or he just didn't give them any restrictions?
There was no, it was a female judge, Judge Myra Dixon, and she said that they could touch his hands. Yeah. There was never any question of them talking to him. That would be improper. Yeah. But his hands were evidence, and they were allowed to examine the evidence. And that issue went to the Georgia Supreme Court, and ultimately the trial court allowing us to do that was upheld.
Yeah. In other words, they appealed it because they said the judge should not have allowed this.
That's exactly right. And the Court of Appeals and later the Supreme Court said what the judge did was perfectly appropriate.
How long did this case take to get resolved? Because you did come up with a verdict, what, $4.4 million?
For about approximately $4.5 million. Yeah. It took roughly 3 years before we finally got the case resolved. Three and a half years if you count the appeal. And that's not unusual, unfortunately. They do take a while if they go to court.
What is have they changed, what happened to the medical tech that did this? Anything? Nothing?
Nothing to my knowledge. Yeah. It's very rare for there to be consequences.
Unless you continually make mistakes.
Even then, there are examples where the medical professional keeps their job without consequence.
Right. What do you find most unusual about this case? Why is this kind of a favorite case of yours?
The issue of allowing the jury to touch the client and to feel his skin, feel the temperature, was a very controversial issue in Georgia. and it's highly discretionary with the trial judge. But typically, the jury doesn't interact at such a personal level with the plaintiff.
Yeah, so this case set a precedent, actually, by going to the Georgia State Supreme Court, right?
Well, there was actually a precedent from over 100 years before where a jury was sitting in a DUI case, or excuse me, a bootlegging case, and one of the issues was whether the liquid that was in evidence was alcohol. So the jury asked for an opportunity during deliberations, to test the evidence.
Seriously.
And then they felt a need to test it again and again and again and again.
Oh, wait a minute here. Were they sober at the end of the deliberation?
Well, I don't know, but they did conclude that it was alcohol.
Wow, how did you find that case?
Well, I had a wonderful co-counsel who's an appellate attorney named Darren Somerville, and he found this case. And
that was the basis of substantiating.
This was a huge part of the case, on appeal.
How interesting, very interesting. Well, congratulations for your verdict.
Thank you very much.
When we talk about medical malpractice, you know what it is, I know what it is, but a lot of people don't know what that is. What does it mean, medical malpractice, and how common is it?
Well, the simplest way to think about it is medical malpractice is when a healthcare professional is not doing their job.
Right.
They're not showing up on time to treat a patient. They're not giving the right medicine. They make a mistake during surgery. They fail to follow the safety rules that are in place to keep patients safe.
Okay, but as a layperson, how do we know this? You know, they go behind closed doors, they're operating on something. We don't know what happened. How do we find out?
Well, it's very hard to find out sometimes because as you touched on, the medical professionals are not always forthcoming when they make a mistake, although they're required to be fully transparent. So what the patient is often left with is they have to find an attorney to investigate. They may not know if they have a case at all. They may suspect they do. You know, say a patient goes in for a routine operation and they come out brain damaged.
Right.
You know that something went wrong, but the doctors will look at you sometimes and say, well, that's just a known risk. Sometimes these things happen. So it takes hiring a lawyer to dig into the facts, examine the medical record, and get to the bottom of it.
In your career, have you ever come across a doctor, whether it was your case or someone else's, where the doctor came out and said, I did this, I screwed up?
It has happened, but it's very rare.
And when that happens, what happens to that doctor?
Well, usually when that happens, the patients won't file a lawsuit.
What about the medical, and no lawsuit, no insurance claim, right?
Well, that's part of the sort of counterintuitive.
Yeah.
The more that medical professionals are open and honest with their patients, and there's studies that show this, the less inclined the patients are to file a lawsuit. Because people do make mistakes. Sure. It's when people make a mistake and they don't own up to it and they try to hide it or alter the records to conceal it. You know, that's where people they get really upset about that, and rightfully so.
For everybody that's watching this show and they think they may have a potential medical malpractice case, they suspect it, okay? What is the very first step that they should do? And before you answer the question, let me ask you this. Does a patient have the right to get all of the records that pertain to them in this particular case?
Absolutely. They have a right to their entire medical chart. So the very first step is to get the medical records.
Do hospitals give it up easy?
They are required to. One of the provisions under the Affordable Care Act, sometimes known as Obamacare, is there is a federal regulation that requires hospitals to provide patients their entire medical chart in an electronic format, which makes it very convenient to show to a lawyer and to have it reviewed by a professional.
Yeah. How many potential medical malpractice cases and individuals do you have that come into your office that have already gotten their medical records?
Most of them have received some of their medical records. Now, sometimes the hospital or the medical facility will hold back certain records for different reasons. One reason being that it's potentially damaging information in there. So it does take some pushing to get the complete chart.
When a lawyer gets involved and they request the information, do you find that the hospital and the doctors more easily give up the information?
Usually. Sometimes they resist. Sometimes it takes follow-up letters. Sometimes it takes a lawsuit just to get the complete medical chart. That's happened before.
How do you evaluate? A lot of people say a doctor, treated me badly. This is a medical malpractice case. How do you evaluate whether you have a good case?
Well, the first step is to determine what the injury is. If it's a significant injury, then we'll go to the next step to get the medical records and examine it. And we do that by retaining the best experts in the country to review the case. And our direction to the expert is, you tell us the truth of how you see the case. We don't give them any background information so that they're not biased as they review the case. Right. And if they come back and they tell us there's no case, or the doctor did the right thing, or this is a known complication, right, then we, of course, tell the family that, and the family is very satisfied to have that information because they can get closure and move on with their life.
Right. Now, these are practicing physicians. Are they practicing physicians, these medical experts?
Yes.
So they are local, is that correct?
They are not local. Well, rarely are they local. It's very difficult to get a local physician to review a case against a local.
Right, because if he decides to review a case, he's probably going to be testifying if the case goes to court, right?
That usually happens, but sometimes doctors will review a case with the understanding that they will not make themselves available to go to court. Some doctors just aren't willing to do that.
Yeah, but they are willing to make a report, would put their name on it.
Make an affidavit and say, yes, there was malpractice. That does happen. But that's not typical. Normally, the doctor's willing to sign an affidavit. They are willing to go to court.
Yeah. One of the significant factors of this $26 million verdict is not only did it come in quickly, but it's a large amount of money that was paid quickly. Why was it paid quickly?
Well, you touched on it. That typically does not happen in these cases, but Georgia has a statute which allows the plaintiff's attorney to make a motion for attorney's fees after a verdict is returned, and the jury decides if attorney's fees are warranted. And there's a certain standard that they have to follow. In this case, we made that motion after the verdict came back, and the defense wisely made the decision to go ahead and pay the verdict and not allow the jury to increase the amount of the money received by the plaintiff, because this jury was obviously closely connected to the plaintiff and was motivated to do the right thing.
If a victim has a legitimate case, medical malpractice case, what is usually the time frame from the time they walk into a lawyer's office to say, would you examine this, would you review this, till the time they can end up getting it settled or go to court? What are we talking about, years?
There's a lot of variation there. Some on the shorter end, the cases can resolve as early as 6 months to a year. Typically, though, they can take up to 1.5 years to 2 years to resolve.
In the interim period of time, oftentimes a patient is being hit with a lot of medical bills. What do you say, does a lawyer get involved with saying to the people that are looking to collect money from these victims? What do you say to these companies?
Well, that's part of my job, is to help the client not only prosecute their lawsuit, but to help them with all the things going on in their lives. Medical malpractice and an injury that can result devastates people's lives. It takes away their income a lot of times. It brings in an enormous amount of medical bills. So we get involved with their bill collectors and we say, look, there's a lawsuit, leave them alone.
Do they?
Most of the time they do. Most of the time, sometimes they'll ask you to sign a letter saying that if there is a recovery, that you'll pay us back.
Yeah, but do they agree the amount of money at that time, or is that negotiable?
It's negotiable. It's negotiable. It's part of the process of helping the client kind of keep their life together while they pursue justice.
And in many of these cases, you know, some of these medical bills are enormous.
Oh, they're huge.
So do you get involved with negotiating them down?
That typically happens at the end of a case. If there's a recovery, you'll have all these insurance companies saying, we want our money, we want what we regard as our money back. And we'll negotiate with them and say a lot of things. Sometimes we'll say you're not entitled to it, or if you are entitled, let's pay a more reasonable amount. That's part of the representation.
Can you negotiate with Medicare?
You can. Now, they have a much stronger lien than a private health insurer.
Why is that?
Because they're government. It's just how the law has been set up. They're a government payer. So if Medicare's paid $200,000 for medical bills, then they have a lien for $200,000, but they'll typically negotiate with you.
But you can negotiate with them.
You can.
What advice do you give people who are watching this show, who suspect that they might be a victim of medical malpractice? What do you say to them?
my advice is to hire a lawyer to investigate. Lawyers who do this kind of work, the kind of work that I do, medical malpractice, we work on a contingency fee basis. So there's nothing out of pocket from the client.
And that includes the experts. They're expensive.
They are expensive, but we advance all the expenses for the expert witness fees in the investigation. So there's nothing to lose in getting answers. And one of the benefits of pursuing or investigating a medical malpractice case is just to get answers, because a lot of times the answer is your medical professionals did everything like they're supposed to. And if that's the case, then you can at least shut that door and move forward. However, if you find that there has been malpractice, then the client will have a choice to make. Is it worth pursuing? Is this the right thing to do? But at least you have a choice. At least you know what the truth is.
I'm going to give you a figure that I read. 3% of practicing physicians cause 30% of medical malpractice cases. It would seem to stand to reason that if you cleaned up the 3%, I mean, these are not just one event, but repetitive, events that it would seem to reason if you got rid of the bad doctors, you'd improve the medical profession. But that doesn't happen, does it?
Well, I've seen the same statistics you just cited, and it does not happen. And it's unfortunate because most doctors are very good and caring and competent. My father was a physician. I've been in the medical community through my father and through other friends and family members for my whole life. And most professionals are very patient-oriented. However, there are a few who, as you pointed out, contribute disproportionately to the number of malpractice cases. And if those few were addressed by the respective boards, we'd see a dramatic decrease in malpractice.
Right. One last question. How do you select clients? People come to you every day and they're claiming this and that. How do you select them?
Well, it's like you pointed out, it starts with a phone call. It starts with an initial contact. And we talk to them and see if it's a serious case, see if there's an injury that is substantial or a death. And then we meet with a client. And what I'm looking for is a personal connection. I'm listening to the story. We put a lot of emphasis on just focused listening. Let's really find out what their experience is. And if it is a serious injury and it appears to be a serious case, then we'll take it to the next step, which is looking into the records.
Well, I want to thank you for being on the show.
Thank you for having me.
Congratulations on the case.
Thank you very much.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.